Hello，各位线上的贵宾，大家好。坐在我旁边的是Dr. Neubeck 博士，他其实今天早上才刚刚到台湾，那他人现在在我们理律的办公室，很高兴今天有这个机会可以跟大家邀请Dr. Neubeck 来跟大家介绍一下即将在6月1号施行的这个大欧洲的这个统一法院，包括申请跟诉讼的策略。那等一下的进行会用英文进行，各位如果有任何的问题，可以等一下再问，就是或者是随时用这个 Webex 的那个简讯，我们会收到您的问题，然后中文或英文都可以。如果是问题是中文，我们会翻译给 Dr. Neubeck， 他等一下最后会回答。那另外就是今天的这个投影片，它的 PDF 档已经上传到我们理律的官网。那经过 Dr. Neubeck 的同意，各位如果有需要都可以去下载。So now we welcome Dr. Neubeck coming from such a long way from Paris, France, and it's your show now.
Okay. Thank you, Roger. Thank you very much. It's a real great honor to be here today. Be back in Asia. It's my first trip to Asia. And actually my last trip to Asia was also to Taipei and for the APA in 2019. So I'm really glad to be back here and to have the opportunity to present you something we were waiting for a long time in Europe. It's called the UPC and the UP, the Unified Patent Court and the Unitary Patent. I will give you a presentation today, generic introduction, what it is, what we are talking about, what is the UPC, what is a unitary patent. And then I go more to the practical aspect because both are very close now. They are just behind the door. It's getting closer and closer to the start, but I will tell more about this once I'm in the slides. Okay, so let's go to the first topic. What is it we talk about for so many years? It was actually something like 10 years ago that Europe decided to bring the European patent system up to life, not to have it in a national system with so many different countries and so many different possibilities. So Europe created the Unified Patent Court and the Unitary Patent. So a patent that covers a plurality of countries and a court that decides on infringement and invalidity for all of those countries. The expected starting date, I just said it, we are just behind the door. It's 1st of June 2023. It's expected. It's not definite. There's one signature missing from Germany, and Germany will actually proceed with this action once technically the court is ready to start. Now, this is what it looks like. Complicated as usual for Europe. In blue, you see those countries that have joined this new system. They are part of the UPC. Those countries, they signed the contracts, but some of those blue countries like Cyprus, Czech Republic, Greece, Hungary, Ireland, Romania, and Slovakia, they are not yet in the system because they have to ratify it, and there are sometimes some constitutional problems related to it. Some European countries which are part of the European Union decided not to be part of this new system. It's mainly Spain, Poland, but also Croatia. And then, of course, all the countries that are not part of the European Union cannot be part of this new system. And maybe the most famous one is the United Kingdom, but also Turkey and Norway, of course, and Switzerland, which is in IP, a very important country, is not part of this new system. I can skip this one because I just already presented you the countries that are part of it and the countries that are not part of it. So when we start, maybe keep in mind when we start, we have 17 countries out of 27 European Union countries that will be part of the new system. So this slide shows you what the unitary patent is about. The unitary patent is based on a European patent application, which maybe most of you are aware of and maybe also use in your everyday to protect the innovation made by your companies. And the unitary patent then comes to life once the European patent application at the European Patent Office is granted. And actually, once the European Patent Office decides about a grant, there will be a choice to be made. Either you stay with what you know from today, you stay with the classical European patent, or you decide to go to the new unitary patent for those countries that are part of the unitary patent system. And to obtain your unitary patent, there's just two actions to be done. You need to prepare one translation, either into English if the patent application was in German or French, or if it was in English, you can go to one European language of your choice. And you have, of course, to make the request to get the unitary patent, and then it's there, it's alive, and you can exploit it together for all these countries. If you decide not to go with the unitary patent, or for those countries that are not part of the unitary patent system, you can still proceed like before. For those countries where validation needs to be done, you have 3 months to proceed with the requests and the translations, and then you obtain a plurality of national patents, which is the lower part in the slide. And to the right side of the slide, you then see the effect of the second part of the new system, which is the Unified Patent Court. You see when you choose the unitary patent, so the common patent for 17 countries, there's just one court that will be in charge of this patent, namely the Unified Patent Court. If you go via the lower path, the classical European patent, there's actually the possibility to stay with the national courts, at least now at the beginning, for the 7 years transitional period. And of course, for those countries that are not part of the unitary patent. And you can also decide to use the new court system for the classical European patent. That is this dotted line that goes from the lower part to the upper right part to the Unified Patent Court. And if you don't want your patents to be part of this new system because it's completely new, we do not know how the court will react, we do not know how the different judges will apply validity and infringement, you can decide to opt out from the new court system and keep your classical European patent, let's say, safe from any adventure with the new court system, and then you will stay with the national courts just like before. So this was a general overview, and now a little bit more about the court itself. The Unified Patent Court, like any court in our Western world, has a first instance and a court of appeal. The court of first instance has a lot of locations. It is split up into a so-called central division, which is placed in Paris and Munich. The third one was in London, but since the Brexit, London is no longer part of the EU, and for the moment, we do not yet know where the third seat will be. People talk about Milano in Italy or Amsterdam in the Netherlands. Besides the central division, there are local and regional divisions in the member states. So there will be a lot of locations. For instance, in Germany, we have 4 locations, but there will also be locations in other countries, in France, in the Netherlands, in Austria, in Sweden, etc. The Court of Appeal, like most of the European courts of second instance will be in Luxembourg. And coming back to the central division, there's a split of technologies that has been decided. So the Munich central division will deal with mechanical engineering. Of course, Germany, you all know, is pretty strong with mechanical engineering when you look at the car industry, and all other fields, including electronics, which is something that is very important, of course, for Taiwanese industry, will be dealt with in Paris. The third seat was about chemistry and pharmaceuticals, which was supposed to be in London. For the moment, at the beginning of the UPC, those technical areas will be split off between the two seats that we already have, so Munich and Paris. Why is there this splitting of central divisions and local divisions? This has to do with the invalidity actions, because the invalidity actions, the isolated ones that are not linked to an infringement action, they will occur in front of the central divisions. Here's just an overview again of the court system. So in the lower line, you see the first instance courts with the central divisions in Munich and Paris. The local divisions, like I said, example in Germany with 4 different locations, and the regional divisions where more than one country together form one seat of the first instance. For instance, in the Nordic states, where Latvia, Estonia, Lithuania, and Sweden teamed up to have one court. And then above, you have the Court of Appeal, and I have not yet mentioned it, for higher legal questions. The European Court of Justice will then the last instance, which will look into those higher lying questions. Now, to make it a little bit visual, the courts have already been started. They are ready to start. I've already been in Munich in the courtrooms. Actually, the building that you see in the middle is the Federal Patent Court of in Germany, which deals with invalidity, and part of the building will be used for the European Court. The situation in the central division in Paris is different. They have hired dedicated rooms just opposite the court building, the historical court building in Paris. So it's close to the Seine, rather nice area. And if you have the opportunity for an invalidity action in electronics, that's the place where you will be. And then Luxembourg for the appeal board. So this was my generic introduction. I will come back now in more detail, and let's start with the one aspect, which is the unitary patent, because for the unitary patent, there are things that can already be done now. So just to repeat what I said at the introduction, the unitary patent is actually a classical European patent because you obtain it out of the European patent application that you know as of today. And it will be just like a national part, with the only difference, it will cover 17 different countries. And like shown on the slide, there will be more countries that come up once those countries have solved their internal issues related to the way their legal system is set up. Keep in mind, UK is no longer part of the EU and therefore cannot be part of this unitary patent. When it goes to cost, and I come to that topic a little bit later, the initial idea was to make it, let's say, cheaper, but actually in the end it becomes cheaper only for those patents that have been validated in a lot of countries, typically more than 4 countries. Then it is getting financially interesting because the annuities are calculated based on the annuity fees of the 4 most important countries. Now, I told you the unitary patent is getting very close, and actually at the EPO you can already take action because you can decide with your patent applications that are close to grant now, for which you have received a so-called 71.3 communication, which is the intention to grant. For those applications, you can now decide that those applications should become part of the new system. And to be able to do so, you can ask for a request of delay in issuing the decision to grant. So the EPO will wait until the new system is in place, so until June 1st, 2023, with the issuing of the decision to grant, so that patent applications that are now close to grant can profit from the new system if you want to be part of it and if you want to benefit from the opportunities the unitary patent allows you. And at the same time, it's a different request that can be made. You can already today file an early request for unitary effect, so that at the moment the UPC becomes operational, dimension of grant will take place, and you will have a unitary patent as of June 1st, 2023. Instead of doing these new actions, classical ways to await the start of the unitary patent are also already available, which is actually the fact that once you receive the intention to grant, there's always the possibility at the EPO to request for an amendment, a minor amendment, and then actually the application goes back into the examination proceedings, and you will receive a new intention to grant at a later stage. And by that time, we can expect the unitary system to have started. So these are the actions you already have today. So you can already think as of today whether you want to be part or not. Now let's have a closer look to the Unified Patent Code. Actually, at the beginning, when this system was set up, so as I said, 10 years ago, Europe is not the quickest institution, but at least we are getting closer. At the beginning, a lot of practitioners said, this system is complicated, this system is not so cheap, this system nobody will use. Now, over the years, I was attending a lot of conferences with my colleagues all over Europe, and also with in-house people from European companies. And the longer people were looking into it, the more people saw also advantages. So there will be people that will use it. So whenever there's a patent owner, he can decide, at least at the beginning, whether he wants to use the new system or the old system. So there might be always situations where the new system will be used. So if you're on the other side, if you are an alleged infringer, it might be that the patentee will file the first case at the UPC. Because, of course, patent attorneys and especially the patent litigators are very keen to be among the first users and to try out all the new possibilities they have. And this is not only for the new patent, the unitary patent. Remember, the UPC will also deal with the classical EP patents. So the patentee really has a new choice. He can go towards a new code or can keep the old code. We think the UPC will be used when a plaintiff has more than one patent at stake, because then he can decide to take advantage of both systems, one patent in the new court and the other patent or the other patents in the national court. The UPC will be used if there are infringing actions in slow jurisdictions, Belgium or Italy, which are actually famous for very slow jurisdictions, or in inexperienced jurisdictions where people did not file infringing actions before. But now, today, it will be possible because you will use a system that has judges that have a lot of experience, and they will rule also for those countries where before not a lot of infringing actions took place. And people will use the UPC when they are sure about the validity of their patent. When they have a patent at stake that has survived opposition proceedings at the EPO, because then the probability that the patent will be invalidated are actually very low. And then you can take advantage of a centralized attack for 17 countries. And last but not least, this system allows English speakers to use English in nearly every country that takes part of the UPC. German courts most probably will allow English as the language of proceedings. The French local division has already indicated that they will allow not only English, but also German as a language of proceedings. So this also will be something that will trigger cases before the UPC instead of awaiting and letting others be the first at the UPC. But as I said at the beginning, people were hesitating. Today, more and more people say, we will use it. We find it a good idea. We want this system to work. So we will file actions at the UPC. The last line is also something rather relevant and will, I think, lead to quite a number of cases because the invalidity actions at the UPC are allowed to take place in parallel to opposition cases at the EPO. For those of you who have experienced opposition cases at the European Patent Office, you know that they take a lot of time. They take 2, 3, 4, 5 years for a first instance, and then again 2, 3, or 4 years for a second instance. The UPC will be a quick court, so people will file invalidity actions in parallel. There are things available at the UPC that were not available in each country in the European Union. Before, infringing actions were all dealt with in national law, and every national law has its own culture. Even if the text itself is the same, in court it was dealt with differently just due to different ways of looking at court proceedings. So things that were available in France, like the saisie contrefaçon, which allowed a patentee to obtain evidence from an alleged infringer in a rather simple way, can now be carried out throughout Europe, granted by a French local division because they are used to it, and then enforced in a local division in an infringement case in Germany. The UPC foresees an enforcement of a first instance decision without security. Security can be asked for by the court, but it's not mandatory. And it will be possible to have preliminary injunctions rendered by a local division where the culture is very much in favor of preliminary injunctions, like maybe in the Munich local division. But this preliminary injunction will be valid for the entire territory of the 17 countries. So you see, with these new opportunities, people, and especially the attorneys, of course, will look into a lot of new possibilities that can improve the situation and lead to decisions that are very powerful. I already mentioned it briefly. We are in front of a court that tries to be very quick. The first instance today in Germany takes about 24 months. In France, it takes even longer. The first instance before the UPC, less than 12 months. And this not only on infringement, but at the same time on validity. This was asked for by European industry that was implemented into the new system. So we have 12 months for a decision, and you can imagine that means very short deadlines because a lot of actions will take place in these 12 months. And consider, in case you will be in front of the UPC, what that means. 12 months, you have to communicate with your European colleagues. You have to prepare auxiliary requests in case an invalidity action has been raised against your patent. For the defendant, there's just a couple of months to file an invalidity action. So you have to go for a search. You have to find prior art with which you can attack the validity of the patent. And it's not a question of months or years. It's a question of a couple of months, maybe a couple of weeks. That means we will have a lot of people involved in parallel, big teams of litigators, big teams of patent attorneys. But on the other side, for the patentee, after a year, it's done. You have a first decision. You know where you are, and maybe you get an infringer out of the way. This is a short overview how a first instance proceedings will take place. Just like in most of the jurisdictions, there will be an exchange of briefs. What is new in the European proceedings at the Unified Patent Court is that we have an interim procedure with an interim conference where a judge analyzes the situations, asks the parties whether everything has been presented, makes a first assessment whether there are open topics for which the parties need to file further briefs or whether experts need to be heard. And once this interim procedure is ready, is finalized, then oral proceedings will be scheduled. And those oral proceedings are supposed to be ready in one day, but it's also possible to have them a little bit longer. But in any case, if all parties agree, they can be held as visio conferences, which is something we are getting more and more used to in Europe at the EPO, the European Patent Office. Our oral proceedings are now mostly as visio conferences. At the end of the oral proceedings, the decision will be rendered, but the reasons for the decision will be rendered later. And after the first decision, there might be subsequent parts which deal with accounting, damages, and also the costs of the proceedings, who has to reimburse how much to the other party. Which brings me to the costs. There will be court fees. For every action, there will be fixed court fees. In validity action, there's a 20,000 euro fee, which is quite an amount. It's more than an EPO opposition, but as I said, you get a decision within a year. For the infringement action, there's a minimum fee of 11,000 euros and then a so-called value-based court fee, which is related to the value in dispute. And there, the additional fee to be paid goes from about 2,500 euros to 320,000 euros. Roger, are there any questions from the audience? Because maybe this could be a good moment. Not so far. Okay. Then I proceed with more topics on the UPC. This is a very interesting topic. It is about the judges. The judges have been appointed recently in October, and we will have legally and technically trained judges. And the judges that were chosen, especially the legally trained judges, are mainly or are only judges that have been dealing with patent infringement in the past in their local jurisdictions. So we have a lot of German judges that we know from the German proceedings that now have become judges at the European Patent Court. Some of them are even judges in part-time. They stay with their home court, and from time to time they will sit at the Unified Patent Court, and we have full-time judges as well. For the technical judges, the venue is different. Some come from patent offices, some come from law firms, patent attorneys, and some even come from industry. So this raises some questions, of course. You do not want to have a legal judge from your competitor sitting in the panel. So we will have quite some discussions about conflict of interests for the technical judges, and time will show how that will be dealt with. What is interesting in the panels at the local divisions is that depending on where you go, you will have different kind of distributions. In those local divisions in countries with a lot of historical activities in patent infringement, the panel will have 2 judges from that country. So if we take the example of Germany, there will be 2 legally trained judges from Germany in the panel, and the third one will come from another country. You can imagine that those 2 judges from home country, they will apply the law in a very similar way they applied it before. So if you want to take advantage of a certain legal system, you choose a local division in that country. And especially as already today, judges publicly mention how they intend to handle their proceedings. So this will be something that attorneys will look into, depending on the case. You will go to a local division in Germany, you will go to a local division in France, etc. This is different to local divisions with a low number of litigation. Countries where in the past you did not go because it's a small market or the system is not mature. There's only one legally trained judge from that country, and the 2 other judges come from other countries. So you do not have this possibility to take advantage of the past to improve your situation. Those panels with the legally trained judges can always be completed by a technically trained judge. And there, interestingly enough, the nationality does not play a role. Maybe this is because the science behind the technology is the same in every country, which is not the same for the law, of course. The technical judge is not always in the panel. It is there on request of the parties or on request of the judges. Here I already mentioned in this slide our topics that I already mentioned. So judges are influenced by where they come from. But keep in mind that it is a European system, so that over time we are all expecting that the various local divisions, they will more and more apply a common view, especially once we have decisions from the Board of Appeal, which is a central Board of Appeal, one location, one setup. And once we have appeal decisions, then the local divisions have to stick to those decisions and will apply case law that will then be harmonized. So over the years, we will have then a more centralized and more harmonized system. Now, let's go back to the unitary patent. Let's have a more close look on why we should go for it or why we should not go for it. At the beginning, a lot of people talked about costs. It was about translations and it was about annuity fees. With respect to the court system, a lot of people said we want a more easy enforcement. But over time, we had the London Agreement in 2008, which led to the fact that translation costs were drastically reduced for a European patent. Now, for most countries, you do not have to provide a full translation. Then, of course, came Brexit, United Kingdom is not part of the system, but remains a core country for IP, for people that went to countries like Germany, France, UK in the past, and this is maybe 80% of the European patents. They now are in the situation that UK is still there, and the unitary patent actually only relates to Germany and France for the past. So the advantages were not that much. And to make it complicated, not every country decided to join. Spain, Poland, and Croatia, as I mentioned at the beginning, decided to not participate. There are rumors that maybe Spain changes its mind. Spain did not join essentially due to the fact that Spanish was not a language of the new system. So maybe they change. But Poland, they are unlikely to change their mind, and Croatia most probably will also not join, at least not in the next years. The main advantage related to costs of the unitary patent is actually for those patents that in the past were validated in a lot of countries. For instance, pharmaceutical patents where nearly every country was validated. You will now have the possibility to have all these countries, at least 17 out of it, with just one title. When looking at the risks with a unitary patent, most people mention that the risk of losing a unitary patent by a single revocation action is actually the highest risk you have, because before you had 17 patents and 17 invalidity actions. Now, with one action, you can lose your patent in 17 countries. And this is in particular a big threat if you're in a licensing program. If you have licensed your patents in several countries, maybe to different licensees, then it's probably not a very good idea to go with the new system. And you do not want to have this risk of losing your patent, even though it is in 17 countries by just one action. Maybe what is a nice advantage is that you have a single payment of annuities. You do not have to deal with 17 countries. But on the other hand, looking at annuities, you lose the flexibility. Today, most of the patentees, they have a strategy of reducing the number of countries over the years to thereby save on costs, depending on the importance of the patent. So over the time, one after the other, you drop country, and this is no longer available in the new system. What is interesting with the unitary patent is that nobody hinders you from taking advantage of filing divisional applications. And then you can have one patent of the family that goes with the new system and one patent that goes into the classical system by opting out. I come to the opting out on another chapter. So here just a very quick slide on pros and cons. Pros for the unitary patent is one-stop enforcement for 17 countries, cost-effective coverage compared to the situation where you had to go to all these countries for enforcement, simplified renewal administration because there's only one annuity to be paid, and you will be able to predict your risks and your possibilities within the courts because there's just one court, and this court will over the time become a rather stable one, and you do not have to live with diverging decisions in different countries. The cons, the biggest cons, risk of the one-stop revocation, the cost increase because now you have more countries than you were actually doing before. lack of flexibility to slim down the renewal fee distribution. And if you go to the unitary patent, there's no possibility that you can escape from the new court system because there's no possibility to opt out from the new system. As I said, opting out is a topic on its own, and opting out is something you have to think about today, because very soon you have to take action if you want to opt out from the new system. So opting out, actually, I mentioned it in the introductory part, is the possibility for the patentee to say this classic European patent, so not the unitary patent, just the classic European patent, should not be dealt with at the new court. And to do so, I make a declaration with the new court that this patent should not fall under the Unified Patent Court. When would you do this? When you are a licensor, as I mentioned, and you're in many jurisdictions, you do not want a single revocation action to drop all of your patents, because then all your license remuneration will fall at once. This is not the case if you stay in the national systems. If you're somebody that actually only uses your patents in a defensive way, you did not litigate, let's say, over the last 5 to 10 years, then it's maybe not such a big issue and you can stay into the new system. If you have more than one patent in your portfolio for the same invention, you can do a mix. You can opt out one and stay with the other one. It is getting a little bit more complicated for those of you that share patents with others. If you want to opt out, all parties have to agree, and you have to make a common declaration. So it will be the time to look into your portfolio and to filter out all those patents that you hold with other companies, with universities. And then you have to take a common approach. When you're not the true owner, you also have to, of course, think about it, maybe get the register correct, but in the end, this is not the most important issue, as I will show in one of the later slides. Patents you do not want to opt out are the so-called crown jewels, the ones that bring in money, the ones that give you advantage over your competition. Those are patents that still have a long term before them. Those are patents that are already infringed, you know about them. That are patents that are available all over Europe and that have a high profit margin. So this sounds very much like pharmaceutical patents. Those you do not want to have in the UPC at the beginning because of the risk of this centralized revocation action. Unless you are sure about your patent that it is safe, it survived oppositions, it survived invalidity actions, then you can maybe keep it in because then you have the advantage of the centralized attack. If they are weak, you know that there's prior art that might be relevant and bring a lot of chances that the patent will be invalidated, at least in part, then remove it from the new system. If you're not acting, it's not that bad, because the new system also will work. And you can also have the possibility to opt out at a later time. So you can also just wait at the beginning. And if no invalidity action comes, then it's just like before. Now, this slide is maybe a little bit complex, but it's something to think about because the UPC and the unitary patent has created a situation which is completely new. We have countries that decided that you can have a unitary patent and a national patent in parallel for the same subject matter. Before, this was not possible. We called it the interdiction of double patenting. Germany and France have decided to allow a German patent and a unitary patent to be available for the same subject matter. And it will be possible to exploit it. For instance, you attack the mother company with the UPC and the daughter company in the national court. That puts pressure on the alleged infringer. That puts a lot of costs on the alleged infringer. So you might find an agreement more quickly than you did before, or you might lose in one court, but you win in the other one. And so these are possibilities that we did not have in the past and that litigators will propose in the future. So if you have very important inventions, think about filing European patents and national patents. This is, of course, very nice for us as European attorneys. And unfortunately, that will be applied most probably only by patentees that have rather deep pockets, because for the same invention, you have to seek a plurality of titles. But it is something new and it's something very powerful. And therefore, people will use it. This slide is about some practical considerations to give you an idea how this opt-out will occur. So opting out, as I explained before, allows the applicants to avoid the jurisdiction for the classical EP patent. There's no opting out for the unitary patent. It's a complete electronic process with the UPC register. It's a computerized system, completely digital. It is not with the OPO, it's with the UPC. The request has to be done by the true owner. The register with the European Patent Attorney or with the European Patent Office or with the National Patent Office does not need to be corrected. All owners must agree. That is very important. You do not have to do it on a one-by-one case. You can have a list of all your titles that you want to opt out, and you can do it in one run. But the list must be correct. And in the list, you should not have plurality of owners from which you do not have the agreement that they wanted to opt out. That's why the best thing is to use an attorney that is registered with the UPC. So we at Königer, of course, are all registered with the UPC and can do this for you. And we can then do the declaration that all owners agreed to opt out. The opt-out declaration, you do not have to do it before the start, but it can be done anytime within the 7-year transitional period. This transitional period can be extended once, but afterwards, there's no opting out possible anymore. Afterwards, all those patents go to the UPC. But of course, by then, 7 years, 14 years, you can expect a lot of decisions that have been made, and the system is stable and will work well. There's no official fee. There will be, of course, the attorney fee for setting up the lists or for verifying the ownership issues, etc. And opting out is not a final decision. Opting in is always possible. You can opt out, and then you are safe for your revocation action. And once you identified infringers in a lot of countries, you can decide to opt in again and go for your infringement action. Once opted in, a new opt-out, however, is no longer possible. And now comes the important issue, the expecting starting date of the so-called sunrise period, which is a 3-month period just before the start of the new system, will allow people to already file opt-out requests so that at the moment the new system will start, patents that you want to opt out are already out of the system and you are not risking the centralized attack against your patent. So keep in mind the date 1st of March, which means if you do not have yet started thinking about opting out, to look into your patent portfolios at the European Patent Office, whether there are titles that you want to secure from the new system, and where you have to take action. This brings me actually to the end. Our firm has locations on some of the UPC locations. So we are headquartered in Munich. We have a Paris office, so we are present at those two parts where we have the central division relevant for invalidity actions, and we have further offices in Berlin and Cologne. This was my presentation about the UPC and the unitary patent. I think I'm in time. It's 10 minutes to 3. There will be the opportunity for you to have some questions. If not, I already say thank you very much. I hope that I could give you some insight into the new system. It is not that easy. It is not that complicated neither. If you have questions, just do not hesitate. Please write to us. I put my email here. Mr. Blumenroder, who is the second name on the list, he's one of our litigators. He's giving also a lot of lessons and seminars, and he will be the one who is very much into the proceedings. So please do not hesitate. Contact us for any questions you have, and we also have some information on our website. Thank you.
Yeah, thank you. We do have a few questions, but before that, Dr. Neubeck will stay in Taiwan for a few days. So you have his contact information. Feel free to contact him and either try to have a private section to discuss your company filing or litigation strategy. I think that would be really nice to have an in-person meeting directly in Taiwan, where you can discuss questions about the future of Europe.
Actually, this is not completely true. I leave on Sunday to Japan. But I will do the same time zone, so we can organize, of course, few conferences or phone calls. And I'm coming back to Taiwan on a regular basis as I'm having family here. So there will be opportunities.
Yeah, one question about litigation side, that is, if your company has one unified patent, okay, patent one, and you got another Germany patent, national patent. There are different patents, different technology, but the defendant, you believe the defendant infringed the two patents at the same time. Can you bring a litigation case to the UPC and assert the two patents, one UP, another national patent?
Yes, this is possible. This is really new. The only limitation is when those two patents have the same subject matter and the parties at stake are also the same, then only one decision in the end will prevail. And if I remember correctly, it's the UPC. If, however, and which is quite often the case, you can attack two different parties, the daughter company in France and the daughter company in Germany of the infringer, then in any case, you can even use patents that have the same claims. If it's two patents, complete different technology, then you can in any case file cases in both courts.
Okay. Yeah, second question is about when you like to submit delay request, or you like to submit early request, when do we need to pay the issue fee? Is it the time when do we need to make such a request when paying the issue fee, make the delay request or early request?
It needs to be done before payment of the issue fee.
Okay, before. Okay.
Yeah.
So if we submit delay request, does it mean that the after the UP application become laid open? I'm a guy for litigation, so I'm trying.
Unfortunately, I cannot read it.
Let me think it through. Maybe next question. Guilty. Okay, if we do not submit opt-out and the current EP patent in the future UPC operation, so can we assert the EP patent before the UPC or still before the regular national court?
So the classical European patent, for a period of 7 years, you can choose either the one court or the other courts. So you can either go with the new system or you go to the national courts. This is possible at the beginning for 7 years, maybe for 14 if the transitional period is extended. And if you opt out, then you only go to the national courts.
Okay, so that question about prosecution side raised by Daisy, I'm sorry, I cannot 100% translate that question. So maybe Daisy, you can contact Dr. Neubeck.
Yeah, yes, please. Then I immediately respond.
Okay, that's all we got another one. Okay, in the future UPC situation, do you believe we will still have the forum shopping? I mean, try to choose a better code for the patentee, try to find a better code for a better result?
At the beginning, definitely yes. I can take one example where we discussed a lot within our firm. Take software patents. Software patents, very difficult to litigate in Germany. So if you have such a situation, you might not want to choose a local division in Germany. You will go abroad. You maybe choose a Dutch one, or you go to France. If you want to have a certain interpretation with respect to equivalence, I'm working at the moment between Germany and France. The doctrine of equivalence in the two countries is completely different. I have situations after the analysis, we are in the situation of an infringer in France, but not in Germany, and vice versa. And in this case, at the beginning of the UPC, you would of course then choose a local division where it is more in favor of you. Over the years, this will fade away because with the appeal board, they will come to a common approach for the equivalence. But in the first years, yes, there will be forum shopping. And especially also with the judges, because we know those judges, and those are judges historically that come from their countries. So they are deeply into their culture, and they will, for a certain time, still continue to apply their rules. But there's a very big effort by the UPC to deal with that. The judges, all the judges that were chosen are judges that have a lot of experience. And all these judges are currently sitting in Budapest in Hungary for common training, for weeks of common training. So they talk with each other. They try to find the best mode. They try to see how then they can make this court to be a successful court and to be a European court. So at the beginning, forum shopping, yes, very important. There will be a lot of discussions, and over the time, this will fade away.
Okay, I think that's all. And it has been 1 hour. So thank you very much for your priceless time for all the friends online. And thank you very much for Dr. Neubeck. And stay safe. Take care. And we will see each other soon.
Yes, I hope so. Thanks, Roger.
Okay.
Thank you, everybody. I hope you enjoyed the show.
Okay. Bye. Bye.